Hello, everybody, and welcome to our webinar today. My name is Dan Rudderow, and I'm an attorney, and I've been practicing law for about 25 years now. Our firm, Rudderow Law Group, is located in Orange County. Our practice is devoted almost entirely to representing park owners and managers, both mobile home parks as well as RV parks. Today's webinar is going to cover the different legal notices that managers are required to use at RV parks. We will discuss which notices to use for different situations, how to prepare the notices, and finally, how to serve the notices. So let's get started. I had my IT person, Megan. I gave her a lot of artistic license today. So I said for her to give us as many cartoons as she wanted to keep us awake over the lunch hour. So she started with sort of this cartoon of the courthouse. So the first topic we want to cover is, why are these RV notices important? The RV notices are important because, to the extent we do these RV notices correct, they serve as a prerequisite to a successful court eviction later on in the courthouse. So when the park manager prepares the RV notice correctly and serves it correctly, it makes the process go very smooth in front of the judge. By the same token, when somehow a notice was prepared wrong, or a notice was unclear, or there's an issue as to whether or not the notice was served properly, those type of issues are identified by the attorneys in court, namely the tenant's attorney in court. And they can raise a lot of issues in front of the judge. And sometimes we have judges that are not really well acquainted with the RV law. And it tends to just bog down the process and make the legal time with the lawyers take longer, make the courthouse take longer. And so it really can affect your bottom line. Also, in particular, and this is now Megan saying, I guess she thought it would be funny just to say money here. Also, there's a provision under the California Recreational Vehicle Park Occupancy Law that says the judge can award the RV owner or operator up to $500 against the manager each time the manager willfully violates the RV law, which presumably would include violating the law by failing to use the proper notices. So again, it's very important we prepare these notices correct, and if we do, we'll have a more efficient legal process, which in the end will save the park more money. So the first step is, which notice should the manager use? To determine that, we first need to determine what type of RVer we're dealing with. Essentially, what California RV law does is that it categorizes your RV owner or operator as either being an occupant, a tenant, or a resident. And so these are terms of art under the law. So different notices are then required to be used depending upon whether this RVer is an occupant, tenant, or resident. And generally speaking, as we will see in a moment, the categories are designed such that the longer your RVer has resided at the park, the more extensive the notices need to be. So starting off with the first category, that of occupants. So an occupant is defined as an owner or operator of an RV who's occupied a lot or space for 30 days or less. When that occupant fails to pay the rent, perhaps this occupant is paying a daily rent or a weekly rent, or if this occupant fails to comply with the park rules, this occupant is deemed a defaulting occupant and someone who can be evicted from our park. When the occupant fails to pay rent or obey the park rules, the manager needs to prepare and serve a 72-hour notice. The law says that the occupant has the 72 hours to pay the rent and cure the default. And if that happens, then the resident has the right to remain in the park. The law, while very specific allowing the occupant to pay the rent within the 72 hours, actually says nothing about whether the occupant may also cure a park rule violation. So it's not really clear if they have the option to start behaving themselves and complying with your park rules during the 72-hour notice and thereby cure their park rule violation and have the legal right to stay. So this is a little bit of a gray area, and it gives the managers a little bit of discretion. If the manager has someone who's breaking the rules and they give them, this occupant, a 72-hour notice, and obviously if this person doesn't stop violating the rules, you want to go to the next step of having the sheriff or police remove that person, that occupant. But if the person starts behaving themselves during the 72-hour notice, then the manager probably has some leeway there that they can elect to let this occupant stay in the park. Now, in terms of service, we're always concerned with which notice should we use and how should we serve it. So with the occupants, you're giving them a 72-hour notice. And on this part of the law says you can serve your 72-hour notice one of two different ways. First, you can personally serve the occupant, which of course means simply walking up to the occupant and handing the occupant a copy of your 72-hour notice. Or as an alternative, the law says that you can personally serve anyone that's at the RV that's of suitable age and discretion who's occupying the RV. And then you must also post and mail the notice. So as we'll talk in a moment, people are used to personal service or substitute service or post and mail. On this particular 72-hour notice, it says, well, it's really two things. You can either personally serve someone by handing them the notice, or you do a combination. You can serve it to someone that's over 18 at the RV, but you also have to post and mail in order to complete this second method of service. The law says you need to serve it of a person of suitable age, and I'm always telling my clients it basically means if it's a person that appears to you to be over 18. The law doesn't say 18, but just as a rule of thumb, since it's you, the park managers, who are serving all of these notices, and you're trying perhaps sometimes to do service by substitute service, basically as a rule of thumb, you're going out to the RV and you're saying to yourself, does this seem like someone who's probably 18 or older that the law would think would be a suitable age to receive legal documents and thus be served? Go on to the next slide here. The law says that occupants with a physical incapacity that makes it difficult for them to remove the mobile home actually have 7 days to quit or leave. The law says that these people who have a physical incapacity, in order to cure the rent default, still need to cure within the 72 hours. But in terms of not curing the rent default within the 72 hours, physical incapacity occupants have 7 days actually before they're required to move out, before you're having the sheriff come. The park must also serve the 72-hour notice on the city police or local county sheriff, whoever does the evictions. Your 72-hour notice must state that if the RV is not removed within 72 hours, that management has the authority to have the RV removed from the lot to the nearest secured storage facility. So after the 72 hours has lapsed, the police or sheriff then comes to the park and removes the any person in the RV. And then after the police or the sheriff come out and remove any person at the RV lot or in the RV, then management may remove the RV to the nearest secured storage facility. So the significant point of this is that it doesn't necessarily involve the attorney or the court system. Given the fact that these type of people who are in our park are considered occupants who've only been in our park for 30 days or less, the law does not require us to do a big eviction court proceeding. Instead, what the law is saying, look, if this is an occupant who's been in my park for less than 30 days and I want to evict them or remove them, then the law requires just the proper preparation and service of the 72-hour notice, and then giving a copy to the sheriff and to the police to remove the occupants. The law also says that, of course, and we're talking about notices today, but the law also says that you have to have that sign posted at the entry of your park saying that RVs may be removed, similar to signs that you have to have in front in order to permit towing away of vehicles. Let's go to the next slide. So here I wanted to just give you a couple different samples that you can get from Camp Cal now. So this is a sample 72-hour notice to remove the RV based on the occupant's failure to comply with a rule and regulation. We keep it very, very, very simple. We, at the top of the 72-hour, we say to the name of the person, the name of the occupant. We identify the premises, and then we have a very short, email that says that you failed to comply with the park rules, so you've been given this notice of termination, and you need to vacate within 72 hours. This particular 72-hour notice does not say anything about their right to cure. This one just you could use if you didn't want to give them an opportunity to cure. This is a similar one, which of course is the 72-hour notice to pay rent within the 72-hour period, or else quit the premises and leave. And if you don't leave after 72 hours and you don't cure the rent default within 72 hours, then the sheriff or the police can come and have you physically removed from the lot or the space. So now we want to move on to our second category. Our second category, the law calls tenants. And tenants are people that have been in our park for more than 30 days, but less than 9 months. Because as we'll see, when they've been there for 9 months, they become residents. So now in this second category, we're talking about tenants. Tenants are people that have been there more than 30 days and less than 9 months. And so when a tenant defaults, meaning when that tenant doesn't pay the rent or doesn't obey a park rule, basically what's sort of unique about tenants and is sort of key to the RV law is you have basically two choices. The first choice is when the tenant fails to pay rent, the law is requiring you just to serve a 3-day notice to pay or quit. This 3-day notice can't be served until 5 days, till the rent is past due by 5 days. And again, you can serve this 3-day notice by personal service, by substitute service, or post and mail. A common issue that comes up is, do I have to serve both tenants that might be on my RV registration agreement or in my RV rental agreement? Ideally, the lawyers would love it if you could serve both of the tenants that are on the rental agreement. But remember, you can serve these tenants in different ways. So for instance, let's say you have a rental agreement where the tenants are a husband and wife. If you take 2 copies of that 3-day notice and go out to the RV, and let's say only the wife is there and the husband is gone, you can serve the wife by personal service, because you can hand the wife her copy of the 3-day notice, and now you've personally served the wife. But you can also, because this wife is a person who's over 18, you can also give the husband's copy to the wife, and you can go back to your park office and you can mail the husband's copy to him. And then you can have the ability to sign 2 different proofs of service. You're going to have one proof of service where you say my 3-day notice was served on the wife by personal service, and then you're going to have a separate proof of service where you say I served the husband by substitute service, by giving it to the wife who appeared to me to be over 18 and then sticking it in the mail to the husband. Is it devastatingly critical that you serve both of them? And is it going to be a fatal flaw with your notice going into court if your 3-day notice only lists, for instance, the wife and doesn't mention the husband, or you only serve one and not the other? It's probably not going to be fatal to your case. The lawyers that represent parks do have some legal authority that they can cite to the judge in court, which is standing for the proposition that, Your Honor, I have law that says even though I have 2 people on the rental agreement, if I serve only one of them, it's binding on both of them. And so we do have that ability to still get the eviction process through the courthouse. But again, the idea here is to train our park managers to do whatever they can do on the front end to reduce these legal issues, to make things very crystal clear, because it's going to go a lot quicker and easier for that attorney in court if that attorney has the 2 different proofs of service. We can deal with it if we only have 1 proof of service, but again, this judge may not know much about the RV, and we just don't want to be bogged down in court. So it's just, if you give us proofs of service as to all the tenants that are on the rental agreement, we're going to have an easier, more efficient time in court in front of the judge. The law says that the tenant remains liable for all the rent due up until the day that they vacate. I think we've covered this. Let me just, in addition, so with the tenants, your tenant may have defaulted on the rent, and when that happens, the law is only requiring you to serve the tenant with a 3-day notice to pay or quit. Separate and apart for when they default on the rent, the interesting thing about the RB law is if you're dealing with a tenant that's been there less than 9 months, you can actually serve them with a 30-day notice of termination and terminate their tenancy without cause, which is sort of a very big deal under the law, because a lot of these notices say what has to be in the notice, how you serve these notices, and the grounds upon which you may legally terminate someone's tenancy. With tenants, what they've done under the RB laws, they've said, no, with tenants, because they've only been there for 9 months, we're going to say that you got to give them a 30-day notice, not just 3 days. But you can give them a 30-day notice and terminate their tenancy for any reason or no reason at all. And that is pretty useful to the park, because we know how it is for our park managers. We know things are not black and white out there in the park. We know that what often happens is that there might be a tenant in our RV park who's behaving badly, or maybe not real badly. Maybe it's something like they're smoking marijuana in their lot and the smoke is bothering their next door neighbor, and you're getting a lot of complaints. And unfortunately, your park rules don't have any rules about marijuana smoking. So you're feeling like, gee, I just don't have an actual park rule to talk to this guy about. Of course, you're going to talk to this guy or gal and tell this person that you're disturbing your next door neighbor with your smoking, whether it's cigarettes or marijuana or whatever it is. But after they won't knock off the bad behavior, then you can sort of bypass the fact that you don't have a park rule, because if this is really disturbing other people, then you can go ahead and terminate their tenancy by giving them the 30-day notice, and you don't even have to state a cause. And in this respect, I would really recommend that when you serve a 30-day notice, it be very simple, that your tenancy is being terminated, you have to vacate the premises within 30 days. I would actually recommend to you that you do not specify any reasons or causes in the 30-day notice. Why? Because legally, you're not required to. And number 2, if you put something in the 30-day notice about the smoking or the marijuana, it oftentimes is just ammunition for the tenant in court. The tenant will say to the judge, hey, they're terminating me because I was smoking and disturbing others. And Your Honor, I know for a fact that my next door neighbor was not disturbed because he told me he didn't care if I smoked on my lot and the smoke traveled. So if we don't have to put it out there as to why we're terminating this person, why educate our opponent? Why put it in the notice? So on this one, because we don't have to, we want to not specify the reason. Now, we can go on to the next, and we've got 20 minutes into this, and I do want to cover some more ground here, but we go now from the tenant who's resided there up to 9 months, and now we have people that have been in our park longer than 9 months. And what the law does is it says, I don't know why the law picked 9 months, but sometimes things are quirky. And the law decided to say, well, if this RVer, this RV owner or occupant has been in your park for more than 9 months, then we're going to make it more difficult for you to evict this person. And we're actually going to say to you that you can only terminate this person's tenancy for 7 different reasons that we would list under the law. And those reasons are the ones that I think most RV owners and mobile home park owners are familiar with. They're the reasons like they didn't pay the rent, they caused a substantial annoyance to other residents, they violated one of our park rules. With residents, the law now ratchets it up as to what the notices is that you have to give to a resident. So what the law first says is, okay, with your residents, because they've been there for so long, you need to first of all give them a 60-day notice of termination of tenancy. So they have 60 days now in the termination period. And then, as we kind of know from mobile home law, the individual grounds may require additional notices. For instance, you may, if someone defaults on the rent, you have to give them a 60-day notice, plus you have to give them a 3-day notice to pay rent or quit. With the park rules, before you can serve someone with a 60-day notice because they violated your park rules, before you do that, you have to have given them a 7-day notice and given them an opportunity to comply with your park rules during the 7 days. So it's just a lot more in terms of you have to come up with the proper legal grounds and you have to serve multiple notices which have longer periods of time. So this, for instance, is a sample of a 3-day notice to perform covenants or quit and a 60-day notice to terminate tenancy when our resident defaults on the rent. I think this is very straightforward. The next one is a 7-day notice of rule or regulation violation. And I just wanted to talk about this for a moment. When we lawyers are in court, and we're trying to evict someone for violating our park rules, the judge takes the bench and the only thing the judge has is the judge has the law. And the law just says that we have to have given them a 7-day notice. The law doesn't say what has to be in your 7-day notice. So, but we want to make this very user-friendly to the judge. We want to make it very easy for the judge. So I would like to hand the judge a 7-day notice that the judge could read from the bench, and something along the lines like this one, where it's very simply going to be addressed to the resident, identify the premises, identify just those particular rules, and you can write out the rule if it's 1F or 13B or 39C, you can write out the rules. I would say write out all the rules that are in violation. For instance, if someone is standing on their lot outside smoking marijuana and you have 2 different rules you think are being violated, one, that they're disturbing others, and 2, you actually have a park rule that says they can only smoke marijuana inside their RV, then by all means, what you're doing as a park manager is you're reviewing all of the park rules and you're putting all of the ones that might be violated or are violated in this 7-day notice. You then want to just say really briefly, in short sentences. This does not have to be a book. It just has to put the person on notice. What are the facts upon which you allege that they're violating the rule? And it could be something like, on August 22nd, you were observed smoking marijuana standing on your lot outside. And then the 7-day notice ideally should say, what does this person need to do to comply with your park rules? For instance, if they were violating a park rule that they had too much trash on their lot, you might want to say, within the next 7 days, you need to comply with our park rules by cleaning up the trash on your RV lot. With judges, it's all about due process. Judges want to see, was this resident given their due process? Were they put on notice? And were they given an opportunity to cure their bad behavior during the 7 days? If a judge sees that you explained everything pretty thorough to put this resident on notice, and then this resident continued to misbehave or violate your park rules after the 7 days expired, your chances of succeeding in court and having the judge rule in the park's favor go up a lot. By the same token, if the 7-day notice is very unclear what you wanted this resident to do, the judge may scratch his or her head and say, I'm not really sure you gave a really good 7-day notice because it's not clear to me as the judge what they had to do to comply with your park rules. I think these are just what I just covered. Preparing, adequately explaining things to the resident, and giving as much detail as you can, but not writing a book. I want to talk a little bit about photographs, and I thought Megan, again, did a great job with coming up with this little guy in terms of photographs. Generally speaking, as the lawyer, I would prefer it if you this says carport, but if you, when you take a photograph, perhaps trash that's left all around an RV lot, it's probably a good idea to take these photographs while you're standing on the street in front of the lot or space. I was in court one time during an eviction proceeding on a rule violation where my park manager was up on the witness stand and she was cross-examined by the tenant's attorney as to the photographs and where was she when she took the photographs. And she said in that case, I was standing in the street. I know we have lots of ideas about our legal right to go onto an RV lot, and we know that our attorney told us it's perfectly legal and that we have every right to do what we're doing on going onto the lot. But again, we're trying in these eviction proceedings to take away issues that our opposing attorney can't raise in court. It's just keeping it very simple. And in terms of photographs, judges love photographs. They love the 7-day notice with the photograph attached to the back of the 7-day notice. Again, it's showing the judge, Your Honor, we did everything possible. We wrote them a 7-day notice. We even gave them a picture that was attached to the back of the 7-day notice. And the judge is going to see, gee, you really tried to even show them a photograph of what you were talking about. It would be great if you date stamp the photograph. I think one of my associate attorneys told me there's now an app that you can use for your cell phones to date stamp the photograph. Does the photograph need to be date stamped the exact date of your 7-day notice? Again, we just want to be reasonable. The answer is no, it does not. If it's 1 day off or 2 days off, if you took the photograph on September 7th and you're serving it September 9th, the 7-day notice, that's fine. You're just taking a photograph of this rule violation or this trash or whatever it is, and you're attaching it to a 7-day notice. Again, have I told the resident what they must do to comply with our park rules? And have I signed it and dated the 7-day notice? And have I filled out my own proof of service correctly? Again, with the 7-day notices, the same thing. You can personally serve them. You can serve them by substitute service, or you can serve it by post and mail. And this is just my slide to say that it's very important, obviously, when you come back to your office, while it's fresh in your mind, to try to accurately say in your proof of service, who was it that I served? Even if it's a person over the age of 18, you could put that on there if you're doing substitute service, or the name of the resident, how you served them, checking the boxes, and then signing your name under penalty of perjury that that's the way you did it. And I think we're just about done. I think we made really good time. I know that this was supposed to be for 30 minutes, and I think we got to 29. So I hope all of you have an awesome day. And of course, if you have any questions about RB notices and how to serve them, of course, feel free to contact our office. Have a great day.